with test in determining existence of negligence. So the test to determine the existence of negligence in a particular case may be stated as follows. So this is one that is usually to test the if there is a existence of negligence. Did the defendant in the performance of the alleged negligent act use reasonable care and caution which an ordinary person would have used in the same situation? If not, then he is guilty of negligence. So again, this is the question. Did the defendant in the performance of the alleged negligent act use reasonable care and caution which an ordinary person would have in the same situation? Then if the answer is not, then he's guilty of negligence. The existence of negligence in a given case is not determined by reference to the personal judgment of the actor in the situation before him. The law considers what would be reckless, blameworthy, or negligent in the man of ordinary intelligence and prudence and determines liability by that norm. So again, the law considers. So the answer to the question considers this. Consider these. Considers what would be reckless, blameworthy, or negligent in the man of ordinary intelligence and prudence and determines liability by that norm. When culpa becomes dolo. So when culpa becomes dolo. From culpa, it becomes dolo. From negligence, it becomes to fraud. So when negligence show bad faith, it is tantamount to fraud. Because the difference between culpa and dolo, culpa, there is no intent, deliberate intent. There is no malice. While in dolo, there is the presence of malice or the deliberate intent. So when the negligence shows there is bad faith, it tantamounts to fraud. Hence, the provisions on fraud also apply. Consequently, waiver of an action for future fraud. This is now the prohibited waiver under Article 1171, wherein responsibility arising from fraud shall be demandable in all obligations. Any waiver for action for future fraud is void. Take note, a blanket released in favor of hospitals. A blanket released in favor of hospitals from any and all claims, which includes claims due to bad faith or gross negligence, would be contrary to the public policy and thus void. Even simple negligence is not subject to blanket release in favor of establishments like hospitals, but may only mitigate liability depending on the circumstances. When a person needing urgent medical attention, yes, this is from hospital, when a person needing urgent medical attention rushes to a hospital, an emergency, he cannot bargain on equal footing with the hospital on the terms of admission and operation. He cannot bargain on equal footing with the hospital on the terms of admission and operation. Such person is literally at the mercy of the hospital. Blank released, the blanket released. That's the principle, blanket released. This is from the case of Nogales versus Capital Medical Center, GR number 142625, December 19, 2006, wherein a person is needing urgent medical attention, rushes to hospital, cannot bargain on equal footing with the hospital on terms of admission and operation. That person is literally at the mercy of the hospital. So, Caso Fortuito or fortuitous event. So, this is from the book of Paras. Article 1174. Except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen, or which though foreseen were inevitable. Those events, which could be foreseen, those event which could be foreseen, or which though foreseen were inevitable. So fortuitous event. This is now the general rule for fortuitous events, wherein no liability for a fortuitous event or caso fortuito, that which could not be foreseen, or which even if foreseen is inevitable, very inevitable. So from the book of Rabuya, wherein Caso Fortuito or fortuitous event, but as a general rule, the definition of fortuitous event is that those event which could be foreseen, or which though foreseen is inevitable. It is an event which could not be foreseen, rather, which could not be foreseen, it is an event which could not be foreseen, or though foreseen, inevitable. Again, what is a caso fortuito? Caso fortuito or fortuitous event? It is an event which could not be foreseen, or though foreseen, inevitable. Fortuitous events by definition are extraordinary events, not foreseeable or avoidable. Diba? Not foreseeable, which could not be foreseen. An event which could not be foreseen, or which though foreseen is inevitable. It is therefore not enough that the event should have been foreseen or anticipated, as is commonly believed, but it must be one impossible to foresee or to avoid. It 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 must be one impossible, ba? It is foreseeable, events not foreseeable, but foreseeable is inevitable or unavoidable, cannot be avoided. Though anticipated, but it must be one impossible, like rain, ba? Flood, fire, burning. So, but it must be one impossible to foresee or to avoid. Impossible to foresee or to avoid. The mere difficulty to foresee the happening is not impossibility to foresee the same. The mere difficulty to foresee the happening is not impossibility. It means to say mere difficulty only. You can see um, there is a threat already. There is a threat. Mere difficulty to foresee the happening is not impossibility. Foresee the same. No, it's not. For fortuitous event or caso fortuito, it must be an event with impossible to foresee or avoid. It includes acts of God or force majeure. A fortuitous event may either be an act of God or nature occurrences such as floods, typhoons, or the act of God, floods, typhoons, an act of man, force majeure, such as riots, strikes, or wars. So these are Caso Fortuito, acts of God or force majeure. If acts of God, these are floods, typhoons. If it is a force majeure, it is man-made, riot, strike, war. Effect upon the obligation and requisites. Diba, as a general rule, there can be no liability in case of caso fortuito, which events which could not be foreseen or though foresee inevitable. The rule is that no person shall be responsible for a fortuitous event. That's the general rule. The general rule is no person shall be responsible for a fortuitous event. Hence, the obligor as a rule is not liable for any loss or deterioration caused by a fortuitous event. That's the general rule. No person shall be liable under fortuitous event or caso fortuito. So therefore, the obligor shall not be held liable in case of deterioration or any loss caused by fortuitous event. However, as an exemption, to exempt the obligor from liability for a breach of an obligation by a fortuitous event, the following requisites must concourse. So, in order for the obligor or debtor to exempt themselves from any loss or deterioration caused by fortuitous event, these requisites must concourse. It means to say all of these requisites must be present. There are four requisites. These are: first, the cause of the breach of the obligation must be independent of the will of the debtor. So, the cause of the breach. Cause of the breach of the obligation must be independent to the will. Must be independent of the will of the debtor. So, it means to say, it's independent. It's not on the will. It is not based on the will. Or there is, the debtor has no part in the cause of breach. The debtor or the obligor did not take part in causing breach of obligation. Next, the event must be either unforeseeable or unavoidable. So that the event itself, diba? The event itself must be unforeseeable or unavoidable. It will say that event cannot be seen, diba? It means to say immediately, abrupt. The event happens abruptly, immediately, at one strike, diba? Unforeseeable or unavoidable. When we foresee already the event, it's inevitable. We it's unavoidable. It would really affect, diba? We can foresee already, diba? Event already foresee or can be seen already, but in any manner, it will really cause breach, diba? Because of that situation is unavoidable. Example, flood. We know already that there will be a flood, diba? There is already a flood because of heavy rain. But it is inevitable that the rising of the water or surging of the water is inevitable. It cannot be, even though there is already a high barricade, but it is inevitable if there is a strong rain, continuous rain, so it will abruptly increase the height of the water level. It is unavoidable. Foreseeable, we can see that there is rain, heavy rain, and we are expecting that there will be an increase of increase in water level, then therefore it is unavoidable that it will really overflow the barricade. Next, the event must be such as to render it impossible for the debtor to fulfill his obligation in a normal manner. So, example, event must be such as to render it impossible or for the debtor to fulfill the obligation in a normal manner. Example, there is flood, there is destruction of bridge, diba? So, on that day, the day to deliver the goods, but because of the destruction caused by the flood to the bridge, um, it renders impossible for the obligor to fulfill or to deliver the goods on that day. It is impossible for the obligor to deliver the goods on that day because the event must be such as to render its impossibility, to render it impossible for the debtor. The event must render the impossibility of the debtor to fulfill his obligation in a normal manner. Again, the cause of the breach, diba? The cause of the breach is independent of the will of the debtor. Independent. The cause of the breach of the obligation is independent to the will of the obligor or debtor, and the event must be either unforeseeable or unavoidable. Can be seen already, but it is unavoidable or inevitable. While and also the event must be of that renders must be of must a render must be such as to render, diba? The event must as the event renders the rephrase it, the event causes the impossibility. The event causes or renders the impossibility of the debtor to fulfill the obligation in a normal manner, diba? First, the cause of the breach is independent of the will of the debtor. Second is that the event must be unforeseeable, unforeseeable, or unavoidable. And the event renders the impossibility. The event renders the impossibility for the debtor to fulfill the obligation, fulfill the performance of the obligation in a normal manner. And the last is that the debtor must be free from any participation. It's the same with independent of the will. The debtor must be free from any participation in or aggravation of the injury to the debtor. So that's the last. Diba? The debtor must be free from any participation. Free from any participation or any aggravation to the injury of the debtor. So again, first, these are the requirements. Diba? The general rule is that no person shall be liable, no debtor or obligor shall be liable in case of fortuitous event, provided the cause of the breach of the obligation is independent of the will of the debtor or obligor. Independent of the will of the debtor or obligor. Next is that the event must be unforeseeable, which could not be foreseen, which could not be foreseen rather, which could not be foreseen or unavoidable. Next is that the event renders impossibility for the debtor or obligor to fulfill the performance or of the obligation in a normal manner. And the third is that the debtor is free from any participation in or free from any participation in or aggravation to the injury caused to the creditor. So these are the requisites. As a reminder, these are the reminders. The burden of proving that the loss was due to a fortuitous event, Caso Fortuito, rests on him who invokes it. So, the one who invokes Caso Fortuito must prove it. The burden of proving that the loss was due to fortuitous event rests on him who invokes it. And in order for fortuitous event or caso fortuito to exempt from one liability, it is necessary that one has committed no negligence or misconduct. So, one has committed no negligence or misconduct, or that may have occasioned the loss. If the negligence or fault of the obligor coincided with the occurrence of the fortuitous event, so it means to say the negligence coincides with the occurrence of the fortuitous event and cause the loss or damage or the aggravation thereof, the fortuitous event cannot shield the obligor from liability is for his negligence. So this is if the negligence or fault of the obligor coincides with the occurrence of fortuitous event, the cause for the loss or damage or the aggravation thereof. Therefore, the fortuitous event cannot shield the obligor from any liability. In other words, when the loss is found to be partly the result of person's participation, whether by active intervention, neglect, or failure to act, the whole occurrence is humanized and removed from the rules applicable to the fortuitous event. This is now the exemption. Talking already about the exemption. When the loss is found to be partly the result of persons' participation, whether by active intervention, neglect, or failure to act, the whole occurrence is humanized and removed from the rules applicable to fortuitous event. So it means to say, if the person commits delay, or commits mora, or if the obligor or debtor commits mora, therefore shall be liable even in the case of fortuitous event. Example, if on March 22 will be the date for the delivery, and then failed to deliver that on March 22. On March 23, there is a strong rain, heavy rain that causes floods, that destroys roads, landslides, then those events renders the impossibility to deliver the goods on that day or on 22, diba? Oh, okay, on 22, diba? The date is 22, but incurs delay on 23, March 23. There is a strong flood. Acts of God destroys the road, landslides, that destroys the bridge. Then therefore it renders the impossibility for the debtor or obligor to fulfill the performance of the obligation, or to deliver the thing to be delivered, or to perform obligations oath by the debtor to do. So therefore, since there is delay, there then there is already liability even in the case of fortuitous event.